Good morning, all.
Good morning.
Morning, sir. Morning. I was going to say, I see that we've once again diminished the lights by another notch.
Yesterday, we had indicated that we would be arranging to mark tax policy for a rent-rich economy as an exhibit. We have provided copies, paper copies to my friends and to the court. And on the consent, as I understand it, and given that the witness identified it as his paper, I would ask that the tax policy for a rent-rich economy dated December 2015, authored by Robin Boadway, be marked as the next exhibit, which is Exhibit 76.
Thank you. Thank you.
The second preliminary issue I have was something that came up last night. It occurred to me that yesterday in cross-examination, we spent a fair bit of time with Professor Boadway dealing with what was, or there is a version of this as Trial Exhibit 35. And I'm just wondering if the court, my preference was to mark it as Exhibit 35.1. My friends have said, well, really, it should be an exhibit for identification because it's a lawyer-generated document with the lawyer's comments that the witness has commented on, and the evidence is from the witness. And my question is really one for what would be best for the court. Would it be better for the court to just leave it as part of Exhibit W for identification, or is it easier in terms of the court's analysis at the end of the day to have it marked as Exhibit X separately, or Exhibit 35 or X.35? Is there any preference for the court when the court is reviewing documents? And it's just a practical matter.
Yes, I'm trying to think. You see, if it's with Exhibit 35, then I know where to find it. And the issue is, if it's not with 35, how naming it will remind me what it's attached to without going into the evidence.
Right. So I'm looking for a solution that'll assist.
Is there an objection to it being 35.1 and noting on the exhibit that it's how it was generated?
I'll let my friends speak to that.
Not if we do that.
Okay. Let's do that.
Okay.
I think that would be the best way to.
So updated version of Mr. Schachter's bar charts at 35.1. Would that help, or what would you like to call it?
Bar chart by Mr. Bar chart updated.
Bar chart of economic rents. Is that what it was? Well, you know what, Miss Lewis, you have an idea of what it was.
Exhibit 35 was named Mr. Schachter's conceptual bar charts of economic rents not to scale. So perhaps 35.1 can be updated version of Mr. Schachter's conceptual bar chart of economic rents.
Or perhaps 35 should be renamed. I'd like to say what it is. Conceptual bar chart by Mr. Schachter updated. So what we get in the title, or what we get immediately, is what it is, who made it, and that it's updated from updated Exhibit 35. Is that what it is?
Yes.
And that ties it in. So I did work with the clerk a couple of weeks ago on tweaking some of the exhibit names so that it was the exact thing that one could look for in the first names. And I'm hoping, or I understand, that you get updated exhibit lists as we go along. So, okay, let's try this. So this is exhibit 35.1.
Yes.
All right. Conceptual bar chart by Mr. Schachter, updated exhibit 35.
Thank you.
Okay, thank you. And Mr. Gover's up. Oh, you're ready for your props.
Thank you, Your Honor.
Good morning.
I don't have a compendium, but with the assistance of Ms. Lewis, we'll be displaying certain items that I'll be showing Professor Boadway in the course of the cross-examination.
Thank you very much.
Good morning, Professor Boadway. My name is Brian Gover. I act for 7 added party plaintiffs. They're First Nations in the Robinson Superior Territory, if that helps.
Thank you.
Now, Professor, your participation in this case was not the first time you'd heard of Joseph Stiglitz, was it?
No.
And in fact, you were aware of him and his work previously. Is that fair?
Yes.
Professor Stiglitz is a well-known figure in the field of economics, correct?
Correct. Including in my field.
Including in your specialty field.
Yes.
Is that right?
Yes.
He is well respected in the field. Isn't that right?
Yes, he won a Nobel Prize.
Yes. And you respect him and his work. Is that fair?
Yes.
Now, Professor Boadway, you've written textbooks with Professor Stiglitz. Is that right?
Yes.
And in fact, at Exhibit 60, your nominal report at page 203, we have reference to a text called Economics and the Canadian Economy, published in 1994. And you wrote that with Professor Stiglitz. Is that right?
That's right.
And at that time, Professor Stiglitz was a member of the Council of Economic Advisors in the Clinton administration. Is that right?
I'm not sure, but I know he was a member of that council at one point, yes. I'm not sure of the dates.
And fair enough. Now, you also wrote Principles of Macroeconomics and the Canadian Economy with Professor Stiglitz, and you did that in 1997. Is that right?
Yes.
Now, by then, Professor Stiglitz was Senior Vice President for Development Policy and Chief Economist for the World Bank. Is that right?
Yes.
And Professor, you were and are proud to be associated with Professor Joseph Stiglitz. Is that fair?
Yes.
And in fact, you contributed an essay to a collection in honor of Professor Stiglitz.
Yes.
And Your Honor, we have that at Exhibit 60, the nominal report. It's referred to at page 216. And that was entitled Economics for an Imperfect World, Essays in Honor of Joseph E. Stiglitz. Is that right, sir?
That's right.
That was in 2003?
Yes, that was not the name of my paper. That was the name of the volume, I think.
Okay, you contributed a chapter to a volume that had that title.
That's correct.
Thank you for that clarification. Now, Professor, you didn't undertake that task lightly, contributing a chapter to that book, did you?
No.
And in fact, your chapter constitutes a serious scholarly endeavor. Is that fair?
I hope so. It was a refereed chapter.
It was a tribute to someone whom you respect.
Agreed.
And you respect Professor Stiglitz's opinions on matters relating to economics. Is that fair?
To a particular branch of economics, yes.
Yes, thank you. Now, sir, I'm going to turn to net crown resource revenues and particularly company towns. And you make the point, and this is at Exhibit 62, paragraph 85, and perhaps I'll ask if we can call that up for the court's assistance. Exhibit 62, your response report at paragraph 85. And we'll give everyone a chance to turn that up.
And I actually need the assistance of the reporter, please, for 1 minute. Again. Very good. Thank you for that indulgence.
Thank you. Now, during that brief interlude, we've been able to locate paragraph 85 of your response report.
Yes.
Exhibit 62, we have it on the screen now. And there you say, more generally, Crown expenditures to finance the creation of communities where resource workers reside should be treated as resource-related expenses to the extent that workers do not fully compensate the Crown. And it continues. And so you make the point that Crown expenditures to finance the creation of communities where resource workers reside should be treated as resource-related expenses. Is that right?
In the context of trying to properly measure net resource rents, net of Crown expenses, yeah.
But you acknowledge that in most cases, the resource companies themselves contributed to the cost of building the communities. Is that right?
I agree.
And thus taking the burden off the Crown.
Yes.
And so if we think about Terrace Bay, the community created by Kimberly Clark for its pulp and paper operations, that's an example of a company town built by the company to attract workers to its operations. Is that fair?
I don't know the details, but I take your word for it.
And to make it more attractive for workers, Kimberly Clark created, and you don't know the details, but might create things like housing, a movie theater, a golf course, swimming pool, amenities like that to create the environment for workers to want to work there. Is that fair?
Sounds fair.
And in the example I've given you, the Crown wouldn't bear any of the expense for creating the housing and the amenities. Is that fair, sir?
As I say, I don't know the details of this case, but I can't answer the specifics, but I don't know whether the Crown contributed to, for example, infrastructure in the community or communications or, I just don't know.
That's not something that you analyzed? Is that fair?
No, I was making this comment simply in the context of pointing out how difficult it is to estimate net Crown rents.
Fair enough.
Yeah, sorry, net resource rents. Right. Sorry.
Net resource rents. Yeah. Thank you. And fair enough. We understand your evidence on that point. And on the subject of rents, sir, you agree with me that although you're certainly a well-known economist, you're not an historian, are you?
I'm not an historian.
You're not an ethno-historian.
I'm not an ethno-historian.
You're not an anthropologist?
No.
And you don't hold yourself out as an expert in Crown Indigenous relations in the mid-19th century?
I don't.
And you don't have any special expertise or experience in interpreting treaties?
That's true.
And you're one of the few people in the room who's not a lawyer. Is that right?
I don't know.
One of the best
A
answers we've had.
careful witness.
You don't have a law degree, sir?
I don't have a lot of.
And you don't have any formal legal training?
No.
Now, throughout your...
sorry. I don't know what you mean by formal legal training. I've studied law and economics, let's put it that way.
Fair enough. Thank you for that. Throughout your reports, you make the point that resource rents are not relevant for this litigation. Correct?
Correct.
And you do that, for example, at Exhibit 62, your response report, paragraph 4A. And perhaps we'll display that.
Okay.
That's Exhibit 62, paragraph 4A. And what you say there is that NCRRs and not net resource rents are relevant for this litigation. Net resource rents are only relevant to the extent that NCRRs are a portion of net resource rents. You say that there, is that correct, sir?
That's what it says, yes.
And similarly, in Exhibit 64, your SIR reply report at paragraph 2A, you refer to the Stiglitz and Hutchings use of the concept of economic rents. You conclude paragraph 2A by stating the value of those rents that did not accrue to the Crown as measured by Stiglitz and Hutchings is simply irrelevant. You say that, sir, is that right?
I do, we do.
And by we, you include Professor Smart in that. And you go even further to say, and this is in Exhibit 64, the SIR reply at paragraph 5, that the you say, given that the Stiglitz and Hutchings RHT report and the Stiglitz and Hutchings reply report are of no relevance to these proceedings. You, and by that I mean you and Professor Smart say that. Is that correct?
Yes.
Now, sir, you accept that determining what is relevant for this litigation is the task of the trial judge.
I understand that.
And you're not purporting to dictate to the court what ought to be relevant in consideration of all of the evidence in this matter, are you?
The intent of my use of the word relevant, I thought had been made clear elsewhere in the report that I was giving an economic interpretation and not a legal interpretation of the treaty.
Now, one of the reasons that you argue that the rent framework adopted by Professor Stiglitz and Mr. Hutchings should be rejected is because you say it is inconsistent with the Court of Appeal decision and stage 1 partial judgments. And you say that, sir, at Exhibit 63, your response report at paragraph 30. We have that. That Exhibit 62. I might have misspoken and said 63.
That's not, I don't think that's the SIR reply, but
this is the
report. Oh, okay.
Yes, here we are, paragraph 30. This is Exhibit 62. You say there, this is inconsistent with the Court of Appeal decision and the stage 1 partial judgments. You say that, sir. Is that correct?
Yes.
And that again is you and Professor Smart?
Yes.
And given your lack of legal training, would you agree with me that you don't have any particular expertise in interpreting decisions of the Ontario courts?
Yes.
And again, the determination of what is consistent or inconsistent with the Court of Appeals decision or the stage 1 partial judgment is for the judge to decide. Is that correct?
Yes.
And that's simply beyond your expertise. Is that fair?
Yes.
Now, sir, I'd like to turn to the subject of Dutch disease. And in your response to Stiglitz and Hutchings' use of the economic rents model, you raise the problem of the so-called Dutch disease or the resource curse. Is that right, sir?
Yes.
And you do that in your response report, Exhibit 62, at paragraphs 69 and 70, which I'll ask my friend Ms. Lewis to display. And what you say, Professor Boadway, in describing the issue is the discovery of natural resource deposits does not generally cause a country to grow faster, and it frequently seems to cause growth. Sure. With the quote, it is the discovery of natural resource deposits does not generally cause a country to grow faster, and it frequently seems to cause growth to falter. You say that, sir, and every time I say you, can we take it to be you and Professor Smart?
The royal you.
Let's do that. But you say that, sir, you and Professor
I do, yeah, we do.
And that's because a resource boom, according to the Dutch disease theory, causes wages to rise, which makes other industries less competitive internationally. Is that fair?
That's one of the mechanisms through which the Dutch disease operates.
The term Dutch disease relates to this economic phenomenon occurring in the Netherlands after the discovery of substantial natural gas deposits in the North Sea in the late 1950s. Is that right? So essentially, the discovery of new natural resource deposits might actually harm a region's economic growth?
It could.
And in Exhibit 62
sorry, could I just?
Of course.
The reason I was hesitating is because you specified a region, and I'm not strict. The Dutch disease typically talks about interregional spillover. So I think it's not fair to say that we refer to the Dutch disease as causing a region's rate of growth to decline.
I take your point. Northwestern Ontario might be the region, but we shouldn't take that to be coterminous with the province, for example. Is that fair?
That's right.
So in fact, there could be impacts elsewhere in the province, negative impacts because of Dutch disease or the resource curse. And that's the point of your reference to the region in my question as being a potential source of disagreement. Now, at paragraph 75 of Exhibit 62, you criticize Stiglitz and Hutchings for not accounting for the offsetting effects of the resource curse in their economic rents analysis. And you see, what you say is, and I'll paraphrase, our point is that any such losses due to the resource curse to other industries and regions in Ontario might be offset against the resource rents estimated to have accrued within the, you say RHT territory, we can say RST territory. And you say the Stiglitz and Hutchings report erred in failing to account for such offsetting effects. You say that, sir, is that right?
Yeah, I'm not sure I would use the term erred. We're pointing out here problems with measuring net resource rents. And the problem we're identifying is the fact that you can't simply concentrate on the rents generated within the region. You have to take account of any spillover effects that occur on other regions. That's all I'm saying.
And sorry, and when you say spillover and within the context of Dutch disease, the negative economic spillover.
Negative in the sense that when the resource boom attracts resources from the other region, it causes a reduction in activity in the other region, so a reduction in rents in the other region. That's what's being said.
Thank you.
Professor, you said a moment ago that you're not sure you would use the word erred, but you appreciate you did use the word erred.
Yes, my language is sometimes loose. I use things like relevant when I shouldn't, but there you go.
Well, relevant now erred.
Yes.
That's not a word that in retrospect you feel should have appeared in that report. Is that fair?
Well, you can think of it, I mean, I probably shouldn't have used the word error. I had in mind an error of omission, that they didn't take into consideration the possibility that the rents generated for the Crown, broadly speaking, should take account of any negative rents consequent on resource development, as well as positive rents generated by resources. That's what I meant.
And this in light of a theory that was developed over a century after the signing of the treaty. Is that fair?
Yes, yes.
Now, as we've discussed this, the resource curse or Dutch disease occurs with the discovery of new natural resource deposits. Is that right?
Yes.
And logically, it might also occur if a country was underexploiting known resources and then decided to drastically increase the level of its resource exploitation.
Yes.
Is that fair?
Yes.
For example, exploiting oil reserves that it knew about but wasn't previously extracting.
Yes, that's it. Yes.
And that might also have the same effect on wages that would cause the Dutch disease. Is that fair?
Yes.
But the resource curse is not caused by the government deciding to capture more of the economic rents through taxes or levies on resource industries, is it?
No.
And you understand that Professor Stiglitz and Mr. Hutchings are not saying that the Crown should have increased the level of resource extraction in the Robinson Superior Treaty territory to maximize revenues. They're not saying that, are they?
I agree.
They're not saying that the Crown should have cut down more trees or allowed them to be cut down or allowed mining for more minerals, are they?
Not that I can recall.
They base their economic rent calculations on the level of extraction that occurred in the past. Is that fair?
Yes.
And they base that on the actual number of trees cut down and the actual quantity of minerals taken out of the ground. You understand that?
Yes.
Now, in your testimony on Monday, you discussed this as the difference between the actual rents and the rents with optimal investment. Is that right?
Yes.
And Professor Stiglitz and Mr. Hutchings only sought to estimate the actual rents. Is that fair?
Yes.
They were not discussing the discovery of new resource deposits or the greater exploitation of existing resources. Is that fair? Pardon me, and that I spoke over you. You said yes?
Yes.
Thank you. So nothing in their approach would have caused an increase in the effect of the resource curse in Ontario.
Please repeat the question.
So nothing about their approach would have caused an increase in the effect of the resource curse in Ontario.
Right, but I don't think we're talking about an increase in the resource curse. We're just talking about the existence of a resource curse.
Now, you say, though, that Stiglitz and Hutchings, in calculating the total benefits to the Crown from the resource industries, should have accounted for any losses caused by the resource curse. And in particular, you said that, and perhaps I'll ask Ms. Lewis to display this. It's in your trial demonstratives, Exhibit 74 at slide 57. And the Stiglitz and Hutchings report overestimates resource rents by, and B, neglecting spillover effects that RST resource production has on rents elsewhere. If I taking you to the relevant part of your trial demonstrative, sir?
Yes, yes.
Now, in essence, your argument is that the rents in the RST should be discounted for negative spillover effects elsewhere in the province. Is that right?
I wouldn't go so far as to say that. I'm pointing out here difficulties with measuring net resource rents. I'm not saying that these are easy to measure. I'm saying that we have to be aware of the fact that the net resource rents that were measured by Professor Stiglitz and Mr. Hutchings worked from a set of assumptions, a set of data, and there are reasons to believe that this might overestimate, I should say, the actual net resource rents if they could measure them properly.
Well, the effect of it, though, is that the Robinson Superior Treaty Anishinaabe on your approach would bear the cost through the calculations of their annuities of negative impacts elsewhere in Ontario caused by resource extraction in their territories. Is that right?
No, they wouldn't bear the cost because in our view, the costs are determined by NCRRs, which are not affected by this discussion.
Now, let me put it this way, though. It would still impact on your approach on the share that the Anishinaabe would be entitled to, because net NCRRs are part of resource rents. Is that fair?
Yes, but they're part of resource rents that do not reflect resource curves. They're the rents that were actually collected.
Now, and of course,
by the Crown, sorry.
Pardon me, I didn't mean
by the Crown. No, it's my fault.
And in any event, this idea that resource rents should be reduced given spillover effects is inconsistent with, well, let me put it this way. There's no evidence in the historical record that the shared goals, expectations, and understandings of the treaty parties in 1850 included an offset for the effects of the resource curves. Is that fair?
That's right. I don't think they said anything about net resource rents either.
And to clarify, you didn't identify any evidence that Ontario specifically bore the impact of the resource curves from its extractive territories in the RST territory, did you?
I'm sorry, could you repeat that?
Yes, it's a long question. You did not identify any evidence that Ontario specifically bore the impact of the resource curse from its extractive industries in the RST territory.
No, we didn't.
And you and Professor Smart did not attempt to quantify nor estimate the amount of losses, if any, to other industries in Ontario as a result of the resource extraction that did occur.
True.
As you said on Monday, you did not look at the numbers. Fair?
Well, we did look at the numbers for NCRRs, but not for net resource rents.
But you have no idea what the magnitude of any offsetting impacts on resource rents would be, do you?
No, but I don't think the onus was on us to present such an impact.
And you can't tell us what those losses are or if there were any. Is that fair?
I can't.
Now, turning to tax avoidance behavior, transfer pricing, and transfer payments as a headline here. One of the reasons that you're critical of the economic rent approach of Professor Stiglitz and Mr. Hutchings is because of the possibility of tax avoidance and tax evasion behavior from resource companies. Is that fair?
That's one of the reasons why we're somewhat skeptical about the estimates of net resource rents, which is different than the question of the relevance of net resource rents.
Fair enough. And the portion I've just referred to is in your response report, Exhibit 62 at paragraph 44, where you talk about tax avoidance and tax evasion, both of which are measures for reducing a corporation's tax burden. Is that fair?
That's fair.
Of course, tax avoidance involves legal mechanisms, correct?
Yes.
And tax evasion involves illegal means, correct?
Yes, sorry, when you say, I was hesitant that when you say legal mechanisms, you don't say, you're not using the word legal in the sense, you're saying mechanisms that are legitimate.
Not unlawful.
Yeah.
In the jargon of tax lawyers.
Conscious of trying to make legal judgments.
Fair enough. And that's because it is rational and common sense behavior for companies to do whatever they can do, both, let's say, lawfully and sometimes unlawfully, to reduce the amount they pay in taxes. Is that fair?
In the case of lawfully, yes. I'm not sure I would agree with it in the case of unlawfully.
But we can expect that type of behavior from them. Is that fair?
Unfortunately, yes.
And an example that you provide in your report is transfer pricing.
Yes. And
you do that, and we don't need to go to it in Exhibit 62, your response report at paragraph 46. A large multinational corporation with many subsidiaries in different jurisdictions can play with their balance sheet to show lower revenues and higher expenses in high tax jurisdictions. Is that fair?
Yes.
And that would decrease the company's overall tax bill.
Yes.
And we can expect companies to do that.
Yes.
Is that fair? And similarly, if the augmentation clause only required the government to share part of the NCRRs with the Anishinaabe, we can expect the government to do the same thing, that's deflate revenues and inflate expenses to decrease the amount of money to be paid.
I wouldn't say we could expect that, no.
And do you agree with me, though, that provinces have been known to manage their financial arrangements to make it seem that they are eligible for transfer payments, for example?
I'm not sure exactly what you're referring to. Perhaps you could elaborate.
Well, I'm going to suggest that the province of Quebec in particular has been known to manage its financial arrangements to make it appear that it is eligible for transfer payments.
I presume you're talking about hydroelectricity, that it engages in the equivalent of transfer pricing to get hydro revenues in a form that does not affect their equalization entitlement. Is that?
Yes, that's exactly what I'm getting at. So that's an example of a province managing its financial arrangements with the goal of making it appear that they're eligible for transfer payments.
Yes.
Now, you testified on Tuesday that risk adjusting is a standard procedure when it comes to pricing an asset with a risky return.
Yes.
You'd agree with me that this case doesn't exactly present the standard scenario that economists typically deal with.
Absolutely.
And in pricing assets with risky returns, economists are not usually considering treaties that are meant to last until the end of time, are they?
Agreed.
Usually they're not even considering expectations on a 170-year time frame, are they?
Probably the case. I'm not that familiar with economic history literature. I say that's probably the case. I'm not so familiar with economic history literature on the evaluation of long-term assets.
And that,
if you want to think of it as that.
That's very fair of you to state that, sir. Do you agree with me that this case is quite unique in many ways when compared to the standard scenario in economic analysis?
Very unique. And very challenging to an economist, I would say.
Now, in surreply, when discussing the bargaining approach, you state that a fair bargain would be somewhere between what the Crown would be willing to pay for the treaty territories in 1850 and what the Anishinaabe would be willing to accept. Is that right, sir?
That's a basic principle of bargaining, yes.
And perhaps I'll ask Ms. Lewis to display Exhibit 64, the Sir reply at paragraph 44. And essentially, paragraph 44 says what we've just covered in the last question and answer. Is that correct, Professor?
Yes.
So that the fair bargain would be somewhere between the two poles?
That's what we started out with before we did our analysis. Yes, that was our perception.
Now in paragraph 45, you expanded on that and you identified the amount as the amount the Crown would have been willing to pay as the aggregate value of risk-adjusted NCRRs. Is that correct, sir?
Yes.
And you state that the amount the First Nations would have been willing to accept was as a fixed annuity, was a fixed annuity of $10.
That was our assumption.
That was your assumption.
Similar to the Stiglitz and Hutchings assumption, yes.
And you then calculated Vidal-Anderson annuities, as you termed them. And I know that we haven't used that much in the course of your testimony, but you calculate the Vidal-Anderson annuities based on what the Crown would have been willing to pay.
That's right.
Is that right? And that's because your Vidal-Anderson annuities are based on the risk-adjusted NCRRs in the territory.
We actually give 4 different versions of our Vidal-Anderson annuities, one of which is risk-adjusted, the other 3 are not.
Right. But if, as you say, the fair bargain lies somewhere between what the Crown would have been willing to pay, risk-adjusted NCRRs, and what the Anishinaabe would have accepted, a $10 annuity per person, then the Vidal-Anderson annuities that you propose are, by your terms, not a fair bargain, are they?
From the point of view of the Crown, if you accept our estimate of the amount that the Crown would be willing to pay, from the point of view of the Crown, they are fair because the Crown doesn't pay any more than its willingness to pay if it pays Vidal-Anderson annuities based on it.
And that's the point of view of the Crown, correct?
That's the point of view of the Crown.
And that's at one of the poles, correct?
Yes.
And what you said would be a fair bargain would be somewhere between the two poles, correct?
Yes.
Now, if we could go to Exhibit 74, slide 110 of your demonstratives. You present language from the Court of Appeal on the relevance of wealth disparities.
Yes.
And I'm going to focus on the language. This would suggest that the share promised is to be determined not only based on the extent of Crown revenues, but also with reference to the relative wealth and needs of the different communities. Have I read that correctly, Professor?
Yes.
And you noted that this language guided your approach to considering relative wealth disparities in this case. Is that right?
Yes.
Now, in the second quote, you include the Court of Appeal's majority statement that I've just referred to, which refers to both relative wealth and relative needs. Is that correct?
Yes.
And do you agree with me that relative wealth and relative needs are different concepts?
Yes.
But you only sought to estimate the differences in wealth between the Indigenous and non-Indigenous populations. Isn't that right?
Yes.
You did not make any attempt to estimate the different level of needs between the two communities.
That's right.
And the needs of the community, I suggest, could be assessed on an individual level.
I'm not sure I understand the question.
Well, but I'm going to suggest that needs has 2 dimensions, either a communal level, what a community needs, so it can look after its members, and what individual members of a community need. Yes. I'm going to suggest it has Sounds like you've already agreed with my next question. I'm going to suggest so. that those two dimensions must be taken into account in any consideration of relative needs.
Individual and community.
Yes.
You could interpret it that way.
And the needs of a community might include needs like infrastructure.
Yes.
It might include needs like adequate healthcare facilities.
Yes.
They might include needs like safe drinking water.
Yes.
But your analysis in response to the Court of Appeals language was simply to look at the median wealth of the typical Ontario household. Is that correct?
We weren't doing our analysis in response to the Court of Appeals judgment. We were doing our analysis as a response to the Stiglitz and Hutchings paper. We were not given any instructions to do any calculations of relative wealth and needs. It wasn't part of our instructions.
And because that wasn't part of your instructions, you didn't consider gaps in access to healthcare between Indigenous and non-Indigenous people in the Robinson Superior Treaty Territory?
If we had been asked to do so, we would have. We were responding to what was in the Stiglitz and Hutchings report and what they were asked to do.
Fair enough. And you weren't asked to consider gaps in quality of education.
That's right.
You weren't asked to consider differences in levels of employment.
What do you mean asked to?
Well, you weren't instructed to consider.
I don't think so.
And that's your answer applies to differences in levels of employment. Is that right? You
Yes.
weren't asked to do that. You were not asked to consider differences in levels of infrastructure in communities.
That's right.
And you weren't asked to consider gaps in access to safe drinking water.
That's right.
Your approach in considering the relative wealth and needs of the different communities was simply to compare your approach to annuities to the typical household wealth in Ontario. Is that fair?
Sorry, could you repeat that question?
Your approach in considering the relative wealth and needs of the different communities was to simply compare annuities to the typical household wealth in Ontario.
I wouldn't call that our approach to estimating the relative wealth and needs. It was only looking at the relative wealth.
Thank you. Now, you have disagreements with Professor Stiglitz and Mr. Hutchings over the appropriate way to calculate the wealth and well-being gap between the Indigenous and non-Indigenous populations in the treaty territory. Is that right? You arrive at different numbers than they do, if I could put it that way.
I don't have any problem with where the estimated income gaps, if that's what you're asking. We don't have any problems with the actual estimates of income gaps that they performed.
And using your numbers, the amount of hypothetical compensation that you calculate for each Robinson Superior Treaty Territory household is still far lower than your preferred measure of typical wealth for Ontario households. Is that right?
I think it depends which number you look at.
Right. Well, on your model, based on your original numbers, the hypothetical amount of compensation per Robinson Superior Treaty household was $36,505. And we have that in Exhibit 61, your present value report.
Understood. Using risk adjusted annuities, yes.
Yes. Yeah. And even with that revised number, $36,505, the amount of hypothetical compensation that you calculate for each Robinson Superior Treaty household is still far lower than your preferred measure of typical wealth of Ontario households. Is that right?
Yes, it's not the only measure that we propose. We also propose compensation based on one of our other alternatives.
Right, but to directly answer the question,
sorry,
it's still far lower, that amount than your preferred measure of typical wealth of Ontario households. Far lower, correct?
Yes. But by typical wealth of Ontario households, you mean average wealth of Ontario households?
Correct, and we're coming to that.
Okay.
So taking your lowest measure of household wealth in Ontario, the median net worth excluding housing, you estimated at $173,400. And we have that in Exhibit 61 at page 41.
Okay.
And so the typical compensation of Robinson Superior Treaty households is only about 20% of that. Correct? That's our 36,505 number.
You mean using our risk adjusted approach
yes.
for compensating? Yes.
And instead of your number for average net worth, including housing equity, $855,136, the typical compensation for Robinson Superior households drops to about 4%. We're back to the 36,505 number, right?
Yes.
And that's why you conclude in Exhibit 61 at paragraph 129, your present value report, that the hypothetical compensation to Robinson Superior Treaty annuitants per household is, and I quote, evidently small compared to typical wealth, end quote. That's at paragraph 129.
Okay.
And Ms. Lewis has it on the screen now. It's at page 43. And we see those words, evidently small compared to typical wealth.
Yes.
And that's on any of your measures for typical wealth. Is that fair, sir?
Any of our measures of typical wealth, but assuming compensation based on risk-adjusted annuities. Yes.
Right. Back to your risk-adjusted annuity approach, correct?
One of our approaches.
Right. Now, I'm going to ask that we now go to Exhibit 74, slide 110. And your interpretation of the Court of Appeal decision is that relative wealth, and we see this in the last bullet point, informs the share of NCRRs going to RST Anishinaabe, not the total amount to be shared. That's your interpretation of the Court of Appeal decision. Is that correct, sir?
That's my reading of it as an economist, yes.
So as you put it in your discussion with Justice Hennessy on Tuesday, it could impact on the share of the pie going to the Anishinaabe, but not the size of the pie itself, correct?
Yes, I could explain why I said that if you want, but if not, that's fine.
Well, I'm interested in knowing, so please explain.
Well, because we're conditioned, we're conditioned on not giving more than 100% share of NCRRs, because that would violate the no loss provision of the augmentation clause. That's part of why I was saying that it's the share and not the total amount that we're talking about.
And in fact, if we go to slide 112 of Exhibit 74, you later stated, nevertheless, and this is the point you just made, compensation cannot entail Crown incurring a loss, so cannot exceed 100% of risk-adjusted NCRRs. You see that in the second bullet point.
Yes.
Is that correct, sir?
Yes.
That's the point you just made, correct?
Yes.
And your preferred approach in this case shares 100% of the risk-adjusted present value of NCRRs with the Anishinaabe, correct?
Our preferred approach, but not our only approach.
Fair, but in your view, the preferred approach is already at the maximum, isn't it?
100%, yes. We assume when we apply the, quote, preferred approach that 100% of risk-adjusted NCRRs would be paid through an annuity.
On your approach, the Crown can't provide any more annuities to the Anishinaabe without incurring a loss, right?
Whichever approach we take, that would be the case, yes.
And so for that reason, and this takes us to slide 114 of Exhibit 74, for that reason, your analysis of relative wealth, even though it concludes that annuities under your preferred approach would be insufficient to equalize per household wealth levels, does not cause you to change your opinion about the proper share owed to the Anishinaabe. Fair?
Yes.
It does not cause you to change your approach at all, does it, Professor?
I don't understand the general question that you're posing.
Well, let me rephrase it then. So
we did change our general approach from the very beginning that we started our project. We examined 3 other options beside the risk-adjusted approach. So I would say we did change our approach.
But what we're left with, Professor Boadway, is this: no level of wealth disparity would ever cause you to change your preferred approach, because in your view, the preferred approach already represents the maximum that the Crown could share with the Anishinaabe according to the terms of the treaty. Is that right?
That's why we included slides saying that the government was responsible for addressing these issues through other policies.
Thank you very much, Professor Boadway. Those are my questions.
Just let me catch up for one moment, please. Mr. Marcello, anything?
No re-examination. No re-examination, Your Honor.
Thank you very much. Professor Boadway, if I missed anybody? Professor Boadway, my job at this, my privilege at this time of the trial, at the end of every witness, is to thank the witness. And I believe I speak on behalf of everyone here. We are grateful and appreciative of the time, the expertise, and the effort that you have brought to your contribution to this trial. As you and all the other witnesses know, it is an important, difficult, and challenging matter, and we are all grateful for the respect that you have shown the process through your work and your attendance here. Thank you very much.
Thank you, Your Honor.
So, you may leave. We will go into a case conference. And what is your, has anyone checked the temperature upstairs?
I think we can expect warmer than down here.